Hello?
Hello. I'm just waiting to see if everybody's entering before we begin.
Okay.
Do I have everyone for appellants? Yes, I believe so. Okay, welcome everyone. This is the appeal of Nelson Gould Estate. I am Judge Sarah Hosey, the administrative law judge for this hearing, and I want to thank everyone for joining me today. Before we go on the record, I will go over just a couple of announcements and where we are in the appeal following our pre-hearing conference. I know we had some additional briefing, so we'll go over that as well, make sure we have all of our documents on the record. Then once we're on the record, we'll have formal introductions from everyone. If at any time we lose connection with anyone, please let me know right away. So the Office of Tax Appeals will be conducting today's hearing electronically with the agreement of all the parties and participants. I do want to note that today's hearing will be transcribed by Zoom, the platform. So we ask everyone speak clearly and at a regular pace. Please do not talk over each other. And of course, best practice is to mute your microphones if we're not speaking. So today's proceedings will be live streamed and the video recording is part of the public record and will be available online. Please be aware that any information shared during this hearing is publicly viewable. I want to remind today's participants that the Office of Tax Appeals is not a court, but an independent appeals body. The office is staffed by tax experts and is independent of the state's tax agencies. OTA does not engage in ex parte communications with either party, and our decision will be based on the arguments and evidence provided by the parties on appeal in conjunction with an appropriate application of the law. So I have read the briefs and examined the submitted exhibits, and I'm looking forward to the arguments today. So once we go on the record, we'll confirm the issues and enter the exhibits we have into the record. I'm going to go over them briefly so we're all on the same page. At the pre-hearing conference, appellants had submitted exhibit 1, but after the pre-hearing conference, we had additional exhibits. So we have an IRS account transcript, which we will call exhibit 2. We also had a petition for an order to confirm validity of trust from the probate court and the order to confirm validity of trust, which we will call exhibit 3 and 4. We also have a declaration of Scott A. Cudler, which will be called exhibit 5, and a letter from Harold B. Cudler dated August 18th, 2023, which we will call exhibit 6. Going to appellants, does that sound accurate? All the documents we have for you?
Yes.
Yes.
Okay, did you have any other documents you'd be
No.
discussing? Okay. Turning to respondents, we had exhibits A through F, and then we had an additional exhibit G, the business master file. Is that right? Turning to respondents?
Yes, that's correct.
Were there any other documents you plan to discuss?
No.
Okay, did we have any objections to appellants 1 through 6?
No objections. Thank you.
Thank you. And then did we have any objections from appellants on any of the documents A through G?
No
Mr. Cudler?
objections.
Thank you. Okay, so once we go on the record, we will enter those exhibits into the record as evidence. As for today's presentations, I have 10 minutes for each party and then additional 5-minute rebuttal response period for the appellants. Are there any questions from the parties before we begin?
No.
Okay, seeing none. We are on the record. This is the appeal of the estate of Nelson Gould, OTA case number 230814171. It is 1:04 p.m. on March 18th, 2025. This appeal is being conducted electronically via Zoom, led by myself, Administrative Law Judge Sarah Hosey. This appeal is being heard and decided by a single administrative law judge under the Office of Tax Appeals Small Case Program. May I please have the parties introduce themselves for the record, starting with appellant?
Scott Cudler, attorney for appellant.
Harold Cudler, CPA, for the appellant.
Thank you. And respondent?
And this is Tristan Thalhuber with the Franchise Tax Board. With me is Brad Catino.
Thank you. The issue identified on appeal is whether appellants have shown reasonable cause to abate the late payment penalty for the 2021 tax year. Does this issue properly reflect what's at issue in this appeal, Mr. Cudler?
Yes.
Thank you. Mr. Thalhuber?
Yes, it does. Thank you.
Thank you. Okay, as for the exhibits, for the record, filed with the briefing and in response to the pre-hearing conference minutes and orders, we have appellants exhibits 1 through 6 and respondents exhibits A through G. No objections were made to the exhibits, and exhibits 1 through 6 and A through G are hereby admitted as evidence into the record. Any questions or comments before we move to the parties' presentations? Mr. Cudler?
No.
Okay, Mr. Thalhuber?
None from me. Thank you.
Thank you. All right, Mr. Cudler, you may begin when ready.
Okay, thank you, Your Honor. Appellants understand that the burden is on the appellant to demonstrate reasonable cause. And Your Honor, you stated that you have read through all the moving papers and the briefs, and you have an understanding of the facts that have transpired. In this case, we believe that the appellant has exercised ordinary care and there's no willful neglect. And the Franchise Tax Board has really raised no facts to rebut that and that the appellant acted with any willful neglect. This estate is a larger estate, over $3 million, and had about 13 beneficiaries that were across the country. And there's a lot of moving parts here. When the decedent died at the end of 2020, I was tasked as a lawyer and trustee to marshal the assets and handle the estate. And at first, we did have to get a Hegstad petition. There was some accounts that weren't in the trust, and we went about and did that. And that it was in early of 21 we got an order by the court, and through 21 it was a matter of going through 200 boxes that at the decedent's house and going through records. And it took a while to get some of the financial institutions to provide the information to us, which took through 21 at the end of 21. And I turned it over to Mr. Cudler at the end of 21. And then it was his task to take the information he had from being a CPA for years, along with the information, and to start preparing and addressing the tax issues and what the liability was going to be. And again, the beneficiaries lived in different states, so there were different tax laws, and there was issues that Mr. Cudler can explain about some 401ks and things that had to be addressed that couldn't just be addressed simply. And it required some planning, it required some due diligence on his behalf. And we believe that we raised we rebutted the presumption of good cause, and in our brief we stated that the burden should shift now to the Franchise Tax Board to rebut that presumption. That one, the late filing by the appellant is due to reasonable cause and not willful neglect, and there's no facts that there was an intentional failure or reckless indifference of Mr. Cudler as the appellant, and that the failure to timely pay that amount of tax occurred despite the ordinary care and prudence, and that an ordinary intelligent prudent business person would have acted in similar under the circumstances. And here also, we believe that really the purpose of imposing penalties is really to punish or deter future conduct. And obviously, in this case, the decedent's passed on, and the really is no longer living. So we know that won't occur again. Another thing I wanted to raise is about the IRS waiver. I understand that the tax board may follow the IRS abatement of the penalty, but they're obviously not bound by it. But I will let you know that, and it was in my declaration that I contacted the IRS and I spoke to them to try to get some insight into this. And what I was really told was that in their position it was for good cause, and that the computer generates a code, and that's a code that they use. So I know that Mr. Thalvier has argued whether or not these code was for good cause or was it for just a taxpayer that has paid timely over the years. And so there's no way of changing that code, and they issued it to us. So we believe that the IRS acted correctly, and reverse the penalty. And we're hopeful that the tax board would take that same position. And that's really our case. And I'll let Mr. Cutler, because he was his CPA for years and he has some more information he could add to this.
Thank you, Mr. Cudler. Mr. Harold Cudler, would you like to provide some factual testimony? Oh, I don't believe you are muted, Mr. Harold Cudler. Let's see if I can unmute you.
Okay, is that better?
Yes, I can hear you. Thank you. Can I please swear you in before we get your testimony?
Yes,
Okay, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
yes, I do.
Thank you. Please begin.
Okay, as Scott Cudler mentioned, I had been their CPA for over 20 years, more than 20 years probably. And unfortunately, when he passed away, apparently he died alone at his kitchen table. A housekeeper found him the next day when she came in to attend to him. And the issue is, well, as Mr. Scott Cudler mentioned, I have always had a positive response with the Franchise Tax Board. I'm aware that the penalty first-time abatement penalty probably does not apply to trusts. I don't know if the Franchise Tax Board has ever changed that, but my years of experience, and again, I've been a CPA for approximately 40 years. I've been practicing. I've always had a good feeling when the IRS waived the penalty for whatever reason, that usually the Franchise Tax Board did also. They seem to go with the fact that if the IRS did it, FTB will do it. So that was the assumption we were going on. As far as doing estimated taxes, when I did their 2020 return for the trust, I ended up with a negative income, adjusted income of $967. So under that assumption, technically having no tax that year, we did not do any estimate because we really didn't know what was involved in all the documents and everything. And as Mr. Scott Cudler mentioned, he had to go to court. Some of the lenders, the financial institutions, refused to give us the documents. He had to go, and again, there were 13 beneficiaries that we had to get, signatures and everything for. So it went on for quite a while. It took almost, I would say, a good year before we could get all the documents together. So at that point, I had to file something with an extension. I filed an extension for the return, and of course, not having all the documents and what was taxable and non-taxable, we just sort of filed the extension without the making any payments on the taxes. When I finalized the return a few years later, I did include the late payment penalty and the interest, with the assumption that possibly FTB would waive it at some point in time. And that's where we are. I filed the request, and here we are down the road a couple years later. And as I say, I've always had a positive response from the FTB in all my years of practicing. And they always seem to acquiesce to the IRS's position. So I was under the assumption that that would be the case. And that's basically where we stand right now.
Okay, great. Thank you, Mr. Harold Cudler. Was there any other comments you wanted to make, Mr. Scott Cudler? Oh, Mr. Scott Cudler, I believe you're muted.
Okay. No, I
Hey.
think we've said we need to say, and I think it's probably fair to say that this estate was more complex and complicated than many other estates or clients that Mr. Hal Cudler worked through. So therefore, he had good success in the past with the franchise tax, and then I think that the facts in this case were different, and it required an extensive due diligence on his part. And I believe that we've met the burden, and I'm hopeful that that Your Honor can see that.
Thank you, Mr. Scott Cudler. I'm going to move to the Franchise Tax Board, but you'll have an opportunity for a response or rebuttal after their presentation. Mr. Thalhuber, did you have any questions for Mr. Harold Cudler regarding any of the testimony?
I do not, thank you.
Okay, please begin your presentation when ready.
Thank you so much. Again, this is Tristan Thalhuber on behalf of the Franchise Tax Board. As discussed, the sole issue on appeal is whether appellant has established that its late payment of tax is due to reasonable cause. Because appellant did not timely pay its tax for the 2021 tax year by the April 15th, 2022 deadline, the Franchise Tax Board properly imposed a late payment penalty. When the Franchise Tax Board imposes a penalty, the law presumes the penalty is correctly imposed, and appellant bears the burden of proving that FTB's determination is incorrect. A properly imposed late payment penalty may only be abated if the taxpayer establishes with credible and competent evidence that the failure to timely pay their tax was due to reasonable cause and not due to willful neglect. Unsupported assertions are insufficient to satisfy a taxpayer's burden of proof. Here, appellant has not met its burden. Appellant argues that the time it took to complete the various tasks required to administer the estate upon the decedent's death prevented the administrator from timely paying appellant's 2021 tax liability. Furthermore, appellant contends that the relevant documents required to calculate appellant's 2021 tax liability were not available as of the aforementioned filing and payment deadline of April 15th, 2022. Appellant's arguments do not establish that appellant's failure to timely pay was due to reasonable cause. In the appeal of Morin, and that's M-O-R-E-N, the Office of Tax Appeals weighed heavily the taxpayer's efforts to acquire the information necessary to determine the tax liability associated with the distribution from the estate, and held that an assertion that records were difficult to obtain without any substantiation of effort is insufficient to show reasonable cause. To establish reasonable cause, a taxpayer must show that he or she could not have acquired the information necessary to make an estimate of their tax liability. Here, however, appellant provides no evidence to establish when the relevant administrative tasks were conducted and completed, and exactly how they prevented timely payment of appellant's taxes. While appellant provides a California Superior Court petition to confirm trust assets and court order to confirm assets to revocable trust filed on September 29th, 2020 and February 3rd, 2021, respectively, appellant's payment of its 2021 tax liability was due over a year after the court order was filed. Furthermore, other than appellant's own assertion that it was unable to timely pay its 2021 tax liability in full because the relevant documents necessary to calculate its tax liability were not available by the original filing due date, appellant has not provided any evidence regarding what steps it undertook prior to the due date of the tax to obtain the information or to ascertain its tax liability. Moreover, appellant has failed to explain what prevented it from making a timely payment of tax based on a reasonably accurate estimate. Appellant has not established that its failure to timely pay its tax was due to reasonable cause, and as such, it does not establish entitlement to abatement of the late payment penalty. Thank you, and I'm happy to answer any questions.
Thank you, Mr. Thaluber. I will go ahead and go back to Mr. Scott Cudler. You have 5 minutes if you'd like to have a rebuttal or response to the Franchise Tax Board's arguments. You are muted right now. So please begin when ready.
Okay, I'm ready. So we're not just talking about the availability of records, because Mr. Hal Cudler discussed what records he had and what were available, and that is his testimony is evidence in this case. What we're also talking about is the analysis of the tax issues related to these out-of-state beneficiaries that are, most of them were over 50 or 60 years old, and to acquire their consent, get signatures, and to ascertain each of them what specific tax issues relating to their states, because some of the assets in this estate involved some 401ks and some special types of assets. So I think that's important for the record to understand that records is one thing, but also the ability is to ascertain for the benefit of the beneficiaries what the tax issues were. And also the Franchise Tax Board has not really showed that the appellant was willfully neglectful, or that any intentional failure or reckless indifference. And we believe that we have met the burden here. And if Mr. Hal Cudler has anything else to say about that, he can add in.
Mr. Harold
He's
Cudler,
muted.
you're muted. Did you have anything you'd like to add?
Better?
Yes, we can hear you. Thank you.
Okay. I disagree with Mr. Thalhuber's comment of willful neglect. There was no willful neglect. I mean, I don't know if you've ever dealt with financial institutions in a death situation, they're not very cooperative. They want to go through all the bells and whistles and proof of everything. And as Mr. Scott Cudler mentioned, had to get documents from all over different financial institutions. There wasn't just one or two. There were multiple financial institutions. There was also 13 beneficiaries that we had to get signatures and everything for. He had to go to court to get some of the financial records produced by the financial institutions because they did not want to release him. He was executor. He had to go through roughly 200 boxes of records because my client died obviously during the year, and he didn't put together all his tax information. So Mr. Scott Cudler went through all the boxes, tried to get as much information he could, and then passed it on to me. And then whatever we couldn't get, we eventually got from all the financial institutions once he got some of the court orders. So it wasn't like we were, the estate was only about $3 million. Only, but it's not like it was a huge estate, but the complexity of it all, because of so many different moving parts. So when I prepared his 2020 return the trust return for 2020, as I mentioned earlier, we had a negative income. So at that point, I said, we don't know what to pay in. I have a negative income. There was no tax. So we tried to get all the documents timely, but as you know, dealing with financial institutions, it is not an easy task. So it did take time. So I sort of disagree with the willful neglect comment, because, it wasn't intentional. We did what we could do at the time. On the other issue, Mr. Thalhumer mentioned something about not showing reasonable cause. Well, I don't know what reasonable cause. It could be interpreted under many situations. I think death is a reasonable cause. When nobody is there to give us the information that we need. So, I think we proved that we didn't do it intentionally. And, the fact that based on all the evidence of the different moving parts that Mr. Scott Cudler had to deal with and getting all the documents, it did take an enormous amount of time. And how do you estimate when you don't have all the information available to you, and especially when the prior year tax return did not show any tax for the trust? So that in itself tells me that we weren't required to do an estimated tax. However, I understand Mr. Thalhuber's position about April 15th, when the tax return was due. We should have paid something, but we had no idea because we didn't even have all the documents. So having said that, we feel that we have complied with what is reasonable cause. And I don't know what else Mr. Thalhuber would say. There is no, I guess, there's nothing in the franchise tax code that tells you what is reasonable cause, and it's up to the individual trying to make the case. That is my testimony at this time.
Thank you, Mr. Harold Cudler. I appreciate it. Was there anything else, Mr. Scott Cudler, you wanted to add before we wrap
Nope.
up today?
I think appellant rests. We're good.
Okay, thank you. Are there any other questions or concerns from the parties before I conclude the hearing?
No.
All right. Seeing none, the evidence has been admitted into the record. We have the arguments in your briefs, as well as your oral arguments and testimony presented today. We now have a complete record from which to base a decision. I wish again to thank both parties and all participants for their efforts in this matter. This concludes the hearing for this appeal. The party should expect our written opinion no later than 100 days from today. With that, we are now off the record. There are no additional hearings today. Thank you, everyone.
Thank you.